Ladies and gentlemen, please take your seats. Please take your seats. Dan has really done a great job at kicking off the conference and raising a lot of questions, including some things I really hadn't thought about, and very interesting to hear about the organization within Homeland Security. But now we have our first panel, and wow, what a distinguished panel. This is a world-class opportunity for us to hear from 4 sitting federal judges and what their views of the court and national security. I'm really looking forward to this. Without further ado, I'm going to turn it over to our moderator, Judge Silliman. Judge?
Still getting used to that. Thanks, Charlie. I'm not going to formally introduce the judges on the panel. Their biographical sketches are in your program, so I don't want to take time for that. I do want to only say that I've gotten to know all 3 of these judges. Judge Walton has been down here. This is his 3rd time down here. He's been down here for a program that Chris Schrader and some of my faculty colleagues and I put together every year for federal judges, district court, and appellate judges. Judge Davis was one of my students in our first Dean Levy's inaugural judicial studies program. And Judge Sentelle, you know, I always do this when he and I are on the same conference podium. He and I have known each other for a couple of years. Is it, Judge Sentelle?
A little over half a century,
yeah.
I think. And that's not a joke.
Yeah, if you look at our background, we met as undergraduates at a school 9 miles away way back in 1962, and have known each other since then. So, but each of the judges is a greatly respected jurist in their own mind. So I do want to welcome them all back to Duke. Of course, Judge Sentelle from the Court of Appeals for the District of Columbia Circuit, and next to him, Judge Walton from the U.S. District Court for the District of Columbia. But as you also know from the program, he is, until May 18th of this year, the presiding judge on the Foreign Intelligence Surveillance Court. And then sitting next to him is Judge Andre Davis, who is a judge on the U.S. Court of Appeals for the 4th Judicial Circuit. Now, with the advent of 9/11, a lot of legal issues came to the fore for which there was no good case law. When we started military operations in Afghanistan, and detainees were captured and taken down to the spot that was chosen by the Bush administration, Guantanamo Bay, for separate reasons. Questions arose is, what authority do you have to detain them? Is it the President's authority under Article 2, Section 2? Is it the authorization for the use of military force? What about international law? And what rights do these folks have? They've never been in the United States. Does the Constitution apply to them? Do they even have access to our courts to come in and file a habeas corpus petition? And there really isn't a lot of law, wasn't certainly then. So we're going to be discussing that issue. We're going to be discussing the detention issue. And the judges, all 3 judges, have been greatly involved in that particular issue. Another related issue is when you're dealing with Guantanamo Bay, you're dealing with non-U.S. citizens. What about an American citizen? What about a non-resident alien captured in the United States? Can you detain them under the law of war, under U.S. statutory law? And for how long can they be detained without charges? You also get into the issue, again, new and novel under this war on terror paradigm, of can the United States government surveil electronically even United States citizens? You know we're doing it. How do we do it? What's the statutory framework? What is the case law that's evolved on how are we protected under the 4th Amendment from what the government does in surveilling us? And that's something that, again, one of our panel members, Judge Walton, is the presiding judge of the FISA court, will be addressing. There's an ongoing debate on when we have an alleged terrorist that we're detaining, where do we prosecute them? As you know, President Obama started out by saying, and it was in November of 2010, I remember I was at a conference in Washington when the Attorney General came out and said, we are going to use both forms. We're going to prosecute these folks in federal district court, and then we're going to prosecute others in military commissions. Now, that kind of came a cropper when Congress, by statute, precluded that. So the current status of the law is no one, not one penny of government money can be spent to take someone from Guantanamo Bay into the United States for any purpose, let alone prosecution. But we've had successful prosecution crimes in the federal courts. Which is the better one, and what problems do you get when you try to prosecute an alleged terrorist in the federal district courts? And lastly, an issue which I want us to touch upon is there's a lot in the news lately, literally in the news, about reporters leaking or getting leaks from government classified information. What about a journalist who is called before a grand jury and specifically asked, what's your source? What's the law on that? Is there a journalist's privilege, either in statute or in case law? And again, one of our panel wrote the seminal opinion on that, 2005, I think it was, and we'll have him address that. But anyway, that's where we're going this morning with this panel. I want to jealously safeguard 15 minutes at the end, because you'll probably never have a better opportunity to ask a judicial panel questions. So I want to make sure we end up with that. Now, I want to start with my good friend Judge Sentelle and suggest that, as I mentioned in my opening comments, there was a 1950 Supreme Court decision called Johnson versus Eisentrager, written by Justice Robert Jackson, where he initially said that someone who's never been in the United States, who has no contact with the United States, who's detained outside the United States, has no constitutional protection whatsoever, no right to come into our federal courts. Now, Judge Sentelle and Judge Walton on the District Court for the District of Columbia had a great deal of habeas petitions that started to come in from the Guantanamo Bay detainees. The petitions started to be filed 2002, 2003. So I want to start by asking Judge Sentelle if he'll kind of track us through the case law, statutory law from Johnson in 1950, and then going to Rasul, all the way up through probably one of the most significant Supreme Court decisions in this area, the Boumediene case in 2008. So, Judge Sentelle, would you kind of track us through some of that?
Okay, there are 4 cases that you'll need to remember regarding the jurisdiction and the rights of detainees beyond the territorial limits of the United States who are not United States citizens. It's Eisentrager, Rasul, Hamdan, and Boumediene. Scott says Boumediene. I say Boumediene. The first lawyer that pronounced it in front of me said Boumediene. That's the one I'm stuck with. Eisentrager, all 4 of those cases have some things in common. Each of them was decided by my court first. Each of them, the Supreme Court reversed my court. The first one was in 1950. I was not yet on the court. I was not yet out of first grade. The Eisentrager petitioners were held in Germany in a United States-operated facility. They sought to file writs of habeas corpus in the District of Columbia District Court, where Reggie now sits. He was probably not out of the incubator yet. But anyhow, what is now his court, a district judge said, no, we don't have jurisdiction to hear habeas for somebody who is not even in the United States, never been in the United States, not held in the United States, isn't in the district. Came to the court on which I now sit. Judge Presiding wrote an opinion that said, yeah, you got jurisdiction because they've got a constitutional right, and you can't abridge that just by not having jurisdiction. Well, that's not very good law. The Supreme Court said that. It's not very good law. We don't have jurisdiction. They looked at the statute and the Constitution. It became important in the Supreme Court's interplay on Rasul as to which one they were dealing with. But in any event, the Supreme Court said, we don't have jurisdiction. You're right. Dismissed. And that was the law for over 50 years. Then in Rasul, which was Rasul in the District Court, Aloda in our court, Rasul in the Supreme Court, 2003, 2004, the District Court followed Eisentrager, said, no, I don't have jurisdiction. My court agreed. The Supreme Court didn't. The Supreme Court, in a 5-1-3 or 6-3 decision said that the Eisentrager court had been looking at the lack of statutory venue authority type jurisdiction, held that you had to have a petitioner within the district. They said, since then we've changed that rule. You know, we overruled the case in which Aaron's, the case in which we had said that, so that now the habeas statute doesn't require that the petitioner be in the district hearing the case. Therefore, that's out the window. So the constitutional focus of the other court, the prior decision in Eisentrager, is not really going to bind us because that wasn't what they were proceeding from. Dissent said that's wrong. That was what they were proceeding from. In any event, they said there is jurisdiction to receive the petition. Now, understand we are not yet to the point under which they have any rights to be heard. It's just, do we have jurisdiction to decide it? The case is a lot narrower than it sounds like when you first read it, but it said we do have to hear the case. Came back to us. We sent it back to the district court. District court gets a case called Hamdan. Now, the Hamdan litigant has been through all kinds of litigation, so just looking for Hamdan won't find it for you, but Hamdan v. Rumsfeld is the one we're interested in here. In the meantime, Congress had acted. After the Supreme Court had said we had jurisdiction, Congress came in and said, no, you don't have it anymore. No judge, no court of the United States has jurisdiction for an application for writ of habeas corpus by or on behalf of an alien detained by the Department of Defense at Guantanamo Bay, Cuba. District judge read that, said, I don't have jurisdiction. We read that and said, no, we don't. Supreme Court read that, and about 5-4, I think it was this time, they said, yeah, we do. They said the statute does not apply to cases that were pending at the time of its enactment. So they sent it back again, went back to the district court. Then came the case, the Boumediene decision, that finally gets in the end of it to the rights, actual rights as to whether the petitioners have a right to habeas or whether we just have jurisdiction to hear them complaining about it. In the meantime, Congress acted again, passed the Military Commissions Act that said that part about it not applying to cases that are now pending, forget it. This applies to any case whatsoever. No court has jurisdiction. District court took him at the word. The counter-argument is that if they have a right to begin with, then under the suspension clause of the Constitution, Congress can't take it away. So we now are getting to a more core constitutional question. The two lower courts, one Reggie sits on, the one I sit on, said Congress had taken it away. The Supreme Court, in a lengthy majority, lengthy dissent, went the other way and said that the constitutional right to habeas corpus does extend to an area under the subjection of the United States, even if it's not within the territorial jurisdiction. Going to be just a minute more, Scott, then I'll give it back to you. But it's two different ways of looking at the Constitution. Does it restrict the power of the government, or does it grant the right to the individual? I'm very much paraphrasing the Supreme Court, but I think most of us would say, yes, it limits the right, the power of government, but that power can't be limited by the courts unless somebody has standing to challenge it. We didn't think the petitioners had a right on which they could challenge it. Supreme Court disagreed, and that left us where Scott said we were, where we now have had all the, however many prisoners there are in Guantanamo, it seems like we've had a few petitions from each of them for habeas.
Yeah. And as Judge Sentelle said, in the 2008 opinion of the Supreme Court, written by Justice Kennedy, who many believe to be the swing justice on the court, was sweeping as far as setting out three different factors which you're supposed to apply as far as whether someone comes within the scope of the suspension clause of the Constitution. But the very fact that the Supreme Court in 2008 took it beyond citizenship or even presence in the United States was what caused a lot of surprise among those of us that were watching the case. Now, one of the issues in the Boumediene case, or Boumediene case, however we want to call it, was Justice Kennedy was very sweeping in his constitutional analysis. But it was strange in many ways because before that case, Judge Sentelle's Court of Appeals had review authority to look at the combatant status review tribunals at Guantanamo Bay, which Justice Kennedy, in his opinion, criticized as being totally inadequate. But he didn't set them aside. So after the case, you had two paths for the detainees to challenge their detention. They could go to his court, Court of Appeals for the District of Columbia Circuit, on reviewing the decision made at Guantanamo Bay on whether they were properly enemy combatants, or they could file a habeas. And of course, most of the attorneys representing the detainees, and they are excellent attorneys, every one of them, went the habeas route, as Judge Sentelle said. Now, Justice Kennedy remanded the case, Boumediene, back down through the Court of Appeals with further instruction that it be sent down to Judge Walton's court. And I would guess, Judge Walton, that one of the frustrations was Justice Kennedy really didn't give you a whole lot of guidance as far as standards or anything. You had 48 cases. You want to talk a little bit about how you interpreted Boumediene and how you applied it?
I'll call it Boumediene.
Well, it's 2 against 1.
Well, he reviews what I do, so I'm going to call it Boumediene since he does. But no, I'm sworn to abide by the law as instructed by the Supreme Court. I don't necessarily have to agree with it or like it, and I feel that the decision was wrongfully decided. I don't see why a civilian court should be involved in issues as to whether individuals taken into custody on the battlefield should be released by a civilian court. I think that should be a military decision. But be that as it may, the Supreme Court did say that we had jurisdiction. It was very frustrating because, as indicated, there was no guidance given to us as to how we should adjudicate these cases. And I issued a very lengthy opinion setting forth what I perceive some standards should be in reference to how these cases should be heard. And, for example, one of the rulings I made, looking at it from the standpoint of how a trial judge adjudicates issues in the traditional sense, what type of evidence would be admissible in these proceedings? And I said, well, it had to have at least minimal reliability in order for it to even be admitted and for me to consider it. That was rejected wholeheartedly by the circuit, saying that no, anything comes in, and at the end of all of the evidence, you assess what, if any, value or what, if any, weight that evidence should be given. That's contrary to how we normally adjudicate cases, but that's what the circuit said we have to do. So it was very frustrating because here we are trying to plod through a very complex, difficult issue without any real guidance from the Supreme Court. And every time an issue would be decided by us and ultimately decided by the circuit, the Supreme Court has refused to accept cert. So we still don't have any real guidance from the Supreme Court as to how these cases should be decided. I still have a number of those cases which remain open. They are all now stayed at the behest of the petitioners, hoping that other things will happen outside of the legal arena that may result in their release.
Judge Walton, while we're on that, let me ask you, would it help your court to have Congress legislate in this area as far as giving you standards that you could apply, or would that not be a good thing?
I think it would. Since the Supreme Court said we have jurisdiction, I think somebody should be telling us exactly how these cases should be handled. I don't disagree with ultimately how the circuit resolved the matter, but without any guidance, as I said, I tried to set a standard consistent with how I traditionally adjudicate cases, which was rejected. I understand why it was rejected, but you make your best effort. So it would help if we had some guidance from Congress.
So where we are is we've got all the habeas cases from Guantanamo Bay still coming in to the district court, which is where they are all consolidated for judicial economy.
And if I could just say one thing that really concerned me, because we started also to get applications from detainees at Bagram Air Force Base in Afghanistan, analogizing their situation to those who were in Guantanamo Bay and also seeking habeas relief.
Well, let me pick up on that, because it seems to me, Judge Walton, that one of your brother judges, Judge John Bates, had exactly that case, and he took the Supreme Court's Boumediene, I'll go with you guys, Boumediene, and he, I think, actually split the three factors which Justice Kennedy used into six and maybe added a seventh as far as length. And Judge Bates on your court said that the Constitution applies beyond Guantanamo Bay, even to Bagram under those circumstances, which at that time would indicate, well, then it applies anywhere in the world where you may have detainees under the United States government. That came up to your court, Judge Sentelle, and as I recall, you wrote in 2010, you wrote the El Maquala decision. Did you uphold Judge Bates?
No. First, we took the factors and pushed them back into three where the Supreme Court had them. And by the way, that opinion goes through the whole history you heard on those other four cases. So if you want to read one, whether it's well written or not, I don't know. But in any event, that summarizes all that we did before and the Supreme Court did. It's in that McKellar opinion. And I don't defend any pronunciation of that name. The three factors Supreme Court outlined, or can outline for the court in Boumediene, as to whether the right to petition extended beyond our borders to non-citizens, were the citizenship and status of the detainee and the adequacy of the process through which the status determination was made, the nature of the site where apprehension and then detention took place, and the practical obstacles inherent in resolving the petitioner's entitlement to the writ. Now, the difficulty we faced, and Judge Bates faced in his, let me say, Judge Bates wrote an excellent opinion. It comes down to a point of you decide A or you decide B. It's not that we think he was plainly wrong. We just came out differently when we weighed the factors. The difficulty is the Supreme Court has never overruled Eisentrager. So you start with the proposition that you don't have jurisdiction to hear the petition of somebody held beyond the boundaries of the United States who's not got other contacts with the country. They've never overruled it. Now, Boumediene goes the other way, but they cite Eisentrager in Boumediene. Boumediene says, well, we do have jurisdiction over these prisoners at Guantanamo. Guantanamo has been under the exclusive control of the United States for decades. So it's really it's a unique situation. It may be somewhere else in the world that's the same way, but more than anywhere else I know of. However, the Supreme Court's opinion makes it plain that quasi-sovereignty is not necessary for the writ to extend. So, although I wanted to go that way, I couldn't limit it that much. Kennedy's language would not permit that. So we looked at the three factors they laid out, which they say are non-exclusive factors, but anyhow, they're the fact. Well, they don't say they're exclusive. I'll put it that way. They're the factors we have. The first one, citizenship and status of the detainee, adequacy of the process. On the citizenship and status, that was the same. They were not United States citizens. They were citizens of some place other than where they were being held, with a few exceptions. There was an Afghan petitioner in that. Status, they're detainees after being picked up on the battlefield or with connection to the battlefield. Adequacy of process was probably better at Guantanamo than at Bagram. So that factor weighed a little bit in favor of the petitioners. The second factor, the nature of extending the writ to the petitioner. Second, the nature of the site of the apprehension and then detention took place was essentially, on the apprehension, was essentially the same. Their battlefield or related pickups. Now, where the detention took place, that one gets to be different because of the unique status of Guantanamo, but Kennedy's opinion makes clear that's not enough, but it was something that gets at least in the back of your mind. Finally, the practical obstacles inherent in resolving the petitioner's entitlement to the writ. Now, here's where we really looked at Eisentrager and Guantanamo and said, now, is this, in both where the detention takes place and the difficulties inherent in resolving it are more like the air base in Germany than they are like Guantanamo. That is to say, it's not a quasi-sovereign situation like Guantanamo. It's a United States military installation like the one in Germany. They talked in the Eisentrager opinion about the guerrilla warfare that was still going on out there, what they call werewolves in the Supreme Court opinion in Eisentrager. It was still going on. Well, Bagram is more like that than the situation was in Eisentrager. There was an actual scene of war going on around it, so that the physical difficulties were considerably more in Afghanistan at Bagram than they were in Guantanamo, Cuba, where we have subdued that land long ago. So we decided ultimately that this was more like Eisentrager, so still governed by Eisentrager. It did not come within the exception that is virtually eating the rule with respect to Guantanamo. So we reversed John Bates' decision, who John was also on the FISA court, by the way.
So as a result of your opinion, Judge Sentelle, in 2010, the constitutional availability of habeas corpus for non-U.S. citizens was restricted to Guantanamo Bay. Now, if I recall your opinion in McCullough, near the end, though, I think you said it's not in this case, but if it were shown that the government, the United States government, was moving folks to Bagram in order to avoid the jurisdiction of the courts, then that might be another issue. The lawyers representing the detainees are not dumb. So what they automatically did was they seized on that comment in Judge Sentelle's opinion and went back down to Judge Bates and requested permission, were granted permission to refile an amended complaint, and guess what they put? Well, Judge Bates ultimately dismissed the case, 12B, but that's kind of a flavor of how tenuous this area of the law is, as far as what is the authority of the United States, how far does it extend, what are the constitutional rights involved, and where does it apply? Now, up until now, we've been talking about non-U.S. citizens who've never been to the United States. That's the Guantanamo Bay population. But there were two individuals that many of you may recall reading about. Jose Padilla, he's the one that was arrested at Chicago O'Hare Airport, originally to set off a dirty radiological bomb. Amari was a resident alien, but both were captured in the United States and detained by the United States as enemy combatants. And that issue came to the Fourth Circuit. And Judge Davis, your court issued opinions which are related but different from the Rasul case. And what did your court deal with the American citizen issue?
Yeah, before I answer that, if you'll indulge me just one very brief moment. I have to tell you, I suspect my two colleagues here and every federal judge in America on the morning of 9/11 and through the day, somewhere inside them knew that this was a brand new world we were going to be faced with. And I have to tell you, having been a judge on that day, a federal judge, and having observed what the justices and the judges throughout the country have done, I think the American people should be very proud of our judiciary. I really feel that so deeply, because these were, as we all know, just challenges that, frankly, were largely unthinkable and certainly unanticipated when they arose. And so I just, again, if you'll indulge me just that, I think we all should be very proud of our judiciary. But yeah, Padilla, you'll remember, first of all, that Padilla was one of the 2004 cases that went up to the Supreme Court because the government first took him to the Southern District of New York, and then during the proceedings up there, transferred him down to the Naval Brig in South Carolina. And the Supreme Court, in an opinion by Justice Scalia, said, well, we don't have jurisdiction, or at least the district court in New York didn't have jurisdiction. The Second Circuit didn't have jurisdiction because jurisdiction in habeas cases rests largely on venue, where the detainee is being held and who the custodian is. And the court rejected the argument that the custodian was the Secretary of Defense, no matter where Padilla was. So the case came back to our court on remand after the district court in South Carolina had granted relief, and our court reversed. A panel of our court reversed, finding that that Padilla was within the compass of the authorization for the use of military force, that the evidence was sufficient to establish that he had in fact escaped to Pakistan from Afghanistan, and the fact that he was an American citizen, he didn't need to be treated any differently from others who were either actually or effectively captured on the battlefield. And so his detention continued.
What was kind of interesting is after your court issued the opinion, of course, now maybe the government, in its wisdom, was looking at the tea leaves on the Supreme Court on that first opinion and saying, well, if it ever comes back to us, maybe we're not going to uphold the detention of American citizens in the United States. So the government basically came and said, we want him released from military confinement because we want to prosecute him down in the Federal District Court in Miami, Florida. And I think Judge Ludick wrote a very emotional 17-page opinion where he says, wait a minute, not as long as I'm on this court, and the government had to go to the Chief Justice to get him released. Is that correct?
That's exactly right. The Fourth Circuit, and Judge Ludick in particular, no longer a member of our court, of course, felt, shall we say, that technical legal term snookered somewhat, because the government had made a very forceful case that this guy was very dangerous, needed to remain in military custody, and then, as you say, Scott, changed its mind and wanted the Fourth Circuit to undo it. And the Fourth Circuit refused to do so, and the Supreme Court stepped in, and he was ultimately prosecuted in the Southern District of Florida.
And similarly, you had the Almari case, also before your circuit court, not a U.S. citizen, but a resident alien.
Yes.
And I guess your court treated the Almari case along the same lines as an American citizen, that you upheld his detention?
Almari was fascinating. As it turns out, this was a 2005 opinion, and it's interesting because there were 9 members of the court that reheard the case en banc on the Ninth Circuit, or on the Fourth Circuit. So it looked like a little Supreme Court, right? And as we sometimes see with the Supreme Court, it turned out to be 4-1 and 4. So there were 4 judges on the Fourth Circuit who felt that the authorization for military force did not reach Almari, a lawful resident, not a lawful permanent resident, but a lawful resident who was here studying. But 4 members of the court thought that the authorization for military force did reach such a person, never been on the battlefield, as understood. And then our now Chief Judge Traxler was the swing vote. And so Judge Traxler said, yes, the authorization for military force reached Almari, but the process employed by, again, Judge Floyd, now a member of our court, down in South Carolina, so we got reversed again because Judge Traxler thought he was entitled to the full panoply of due process protections unless the government came in and established an overarching interest in national security, and therefore the process to which he would be due would hinge on how the government was able to persuade the district court of the conflicting interest involved.
And again, Judge Davis, I think the government kind of worried about where that case was going. Did the same thing it did in Padilla, and said, we're going to release him from military custody, and he was prosecuted in the federal district courts in Illinois, as I recall.
That's exactly right.
So there's kind of this track record that when you've got either an American citizen or a resident alien in the United States, who the courts have upheld as far as the detention authority of the United States, then the government has chosen not to follow that precedent.
And again, as proof of what I said when I began my remarks, if you want to take a look at, and certainly Judge Sentelle's opinion is another example of it, but if you want to take a look at the truly remarkable work done by Article III judges on behalf of the people of this country, the Almari in-bank opinions, 156 pages or something, but really, it really shines through quite clearly how dedicated the judges were to the principles of law and the rule of law as they struggled with these just unimaginably difficult issues.
Yeah, and this is an area that I think is going to continue to come before all your courts because it may not be coming out of Afghanistan, but obviously the threat of terrorist activity against the United States is going to continue. And presumably the United States will continue to at least capture some of these folks. Judge Walton, I want to come back to you, and I want to leave the detention issue. There's a lot of angst currently among the American populace about electronic surveillance, very candidly. A lot has come out. A lot of government officials have acknowledged that the United States government is surveilling. A lot of citizens are worried about it. Your court has come into the public view a lot more so than it ever did before. And as presiding judge of the Foreign Intelligence Surveillance Court, if you could, particularly for those in the audience in the conference here who are not that familiar with Foreign Intelligence Surveillance Act, could you take us back to 1978 and tell us a little bit about what Congress legislated, and then kind of track us through the Patriot Act change and some of your case law, and also up to the Foreign Intelligence Surveillance Act Amendments Act of 2008, if you could do that for us.
Well, the electronic surveillance is not a new phenomenon. It's something that has occurred for a long period of time in America, dating back to the presidency of Franklin Delano Roosevelt. And progressively, the executive branch has engaged in additional electronic surveillance under the position that it is a national security issue, and therefore the executive branch has the authority to conduct warrantless searches or warrantless electronic surveillance for the purpose of protecting the homeland. The aftermath of the Watergate situation revealed significant abuses that had been committed in the name of national security, ultimately resulting in the adoption of the Foreign Intelligence Surveillance Act and the creation of the court on which I sit, along with a appellate review court. The statute requires that the government be able to identify the target that they want to do the surveillance on, also to be able to articulate that that target is either a foreign power or the agent of a foreign power, and that the facility or location that the government wants to surveil is in fact actively being used for foreign intelligence purposes, or that it's about to be used, and that such information will be acquired if the surveillance is authorized. The court that I sit on initially was comprised of 7 judges. There are now 11 of us. We sit on a rotating basis individually. We do have the authority now to sit en banc. We have not, to this date, since that authority was given to the court, set en banc. It would be very cumbersome and very difficult for us to do that because the matters that we're dealing with involve highly classified information, and the judges who are all throughout the country, 3 of the judges by statute have to be in the District of Columbia area in order to address emergency matters. The other judges are from various districts from throughout the country. And in order for us to hear a case en banc, that would require all of those judges to be able to come to the District of Columbia, to have the opportunity to review the pleadings that have been filed with the court, and have the opportunity to be here to hear the case and then consult with each other for the purpose of drafting an opinion. So it would be very cumbersome, very difficult, and very expensive for us to do that. So we haven't set yet en banc, but we do have the authority to do so. The events of 9/11 did change the landscape, which resulted in the Patriot Act of 2001 being adopted, which was an amendment of the Foreign Intelligence Surveillance Act. And one of the big changes that occurred as a result of that legislation was that previously the government had to show that the purpose for which the electronic surveillance they wanted to conduct was being conducted for national security purposes. The Patriot Act changed that and said that the purpose had to, that there had to be a significant purpose for the surveillance being conducted, and that had an impact because the position that had been taken before the Patriot Act was that the purpose language that existed in the original statute required that it be the primary purpose. So if the primary purpose was not for the purpose of collecting foreign intelligence surveillance, then the surveillance could not be conducted. And the outgrowth of that was that there was a case that came before the FISA court, and the judge at that time, feeling compelled to create a wall between the law enforcement component of the executive branch as compared to the intelligence component of the executive branch, created this wall and said that the two could not commiserate with each other, consult with each other in reference to the surveillance that the court clearly said was authorized. And that case then went to the Court of Review, and the Court of Review said, no, you're wrong, that wall does not have to be created, that the two can in fact consult with each other, the law enforcement component and the national security component, for the purpose of addressing concerns that were facing, the threats that the homeland was facing as a result of the events of 9/11. That was one of the two cases that the Court of Review, that reviews cases from the FISA court, has issued. And that opinion was issued in 2002. The second opinion that was issued by the court was issued by the Court of Review, was the In Re Directive case issued in 2008 by the Court of Review. It was my case at the FISA court level. The only thing I can say about my opinion, which was about a 98-page opinion, because it has not yet been declassified, is that the Court of Review said that it was meticulous. And they did affirm the decision that I had rendered in that case. The statute that was at issue in that case is no longer in place. It was permitted to expire, but the statute permitted electronic surveillance to be conducted of anyone who there was reason to believe was outside of the United States, including United States citizens. And one of the service providers who was instructed to provide information to the government, and this was a warrantless order or warrantless directive given to the provider to provide this information, challenged that in our court and said that the provider should not have to produce that without a court order having been issued. And that position was rejected, went up to the Court of Review, and the Court of Review agreed with that position. There have been a number of opinions that have been declassified recently subsequent to the Snowden leaks. One of the challenges I have in talking about this issue is because of the number of cases that have been declassified, and there's still a number that have not been declassified. It's difficult to keep straight exactly what I can talk about and what I can't. So I've got to be very cautious in that regard, because obviously I don't want to reveal information about matters that the executive branch has not yet declassified. I guess, unless there's some other specific questions which I will seek to respond to, I just want to close by saying that this will be an ongoing difficult issue as a nation that we're going to confront. I fully appreciate the concerns that the American public has expressed in reference to the surveillance that has been authorized by my court. I think the debate was the debate that needed to happen. I think it's unfortunate that it happened under the circumstances that it did, because I think that the leaks have, in fact, subjected us to greater potential harm at some point down the line. I think it is a very difficult balance to make between the need to protect the homeland on the one hand, and on the other hand, to protect the privacy interests that we all cherish as Americans. It's a very hard balance, but I can tell you, based upon what I hear on a daily basis, that there are significant threats that we're facing as a nation, both in the cyber world and otherwise, and we have to be right 100% of the time in order to avoid having another 9/11 or something greater than 9/11. And I can tell you there are a lot of people out there who want to replicate that event. So we have to be vigilant, but at the same time we're vigilant, we have to be appreciative of the fact that the American public has to have confidence in what we do in order for those efforts to go forward. So I think the debate has been instructive, but I do think, as I say, that the leaks have put us at greater risk, because you better believe that those who would like to do harm to us continue to communicate. And now that they know what is being done in order to capture their communications, I'm sure that they are communicating in ways that are making it more difficult for us to capture what is being said and done. And as that progresses, I think that puts us at greater risk, because if we don't know what they're about to do, we'll find ourselves in a pre-9/11 circumstance and find ourselves being blindsided by a catastrophic event.
Yeah, and just a word, many of you may have read in the press or heard in the media a lot of criticism of Judge Walton's court, because they go online and they look at the statistics, and they say thousands of cases, thousands of applications come up to the court, but very, very, very few are ever denied by the judges on the Foreign Intelligence Surveillance Court. What they don't understand is the way Congress worded the statute, and I think it's Section 1805, where Congress said that if the government meets the specific requirements of the statute, in other words, foreign power, agent of foreign power, or the Moussaoui type of case, that the judge, I think the word is the judge shall approve the order, shall order it. So in all fairness to those judges, they oftentimes will return an application to the department for further work, but it's clearly understandable why there have not been denials because of the way the statute's written. But the court, I think, will continue to be in the press. Obviously, everyone knows the president is considering possibilities as far as an advocate that might be on the court and things like that. But surveillance is going to be with us. Section 702 of the Foreign Intelligence Surveillance Act is ongoing. It says exactly as you described it, that if the Attorney General and the Director of National Intelligence believe that the target, who need not be a foreign power, an agent of a foreign power, could be a perfectly innocent person, if they reasonably believe them to be outside the United States, then surveillance can commence. And so that's the law as it currently exists.
If I could just say one thing about those statistics don't tell the whole story. And when I saw these statistics that we're approving 99 or whatever % of the cases that come before us were published, I said, well, I know that that's not a reflection of my experience, and I've been on the court for almost 7 years. So what I told my staff to do when those reports started to come out following the Snowden leak was for us to start to collect our own statistics, because the statistics that you get are statistics from the Justice Department, and those are only applications when a final application is submitted to the court and rejected or approved. Those are the only, that's the only statistic being captured. Well, there's a lot of things that are happening before that occurs, because there is what is called a read copy, which is a rough draft that's submitted to the court. We have 5 lawyers who are national security experts who review that read copy. There's a lot of interchange that takes place between the Justice Department lawyers and our lawyers, and many times those cases don't go any further. That, however, does not count as a rejection. Or there may, as a result of those discussions, be significant alterations of what the government is seeking from the court. They may be requesting to target maybe 7 or 8 facilities, 7 or 8 phone numbers, for example. We may only approve 2, but that doesn't count as 5 rejections. Once it comes to the judge, again, there's another review by the judge based upon input from our lawyers. Again, we may decide that this is a problem case and therefore should not go forward. What the government may do at that point is pull that case and not seek to go forward with a final version. Again, that does not count as a rejection, and the same is true if we modify that application significantly. That doesn't count as a rejection. Our statistics show that about 24% of the applications submitted to us are either altered in some way of a significant manner, substantively, or they ultimately are pulled by the government and the government does not seek to go forward. So this whole myth about the suffice court being a rubber stamp is just not correct. In addition to what Scott said about the threshold that has to be met by the government to authorize an order being issued by the court is not significant. So I think we do our job, and I think we do it diligently, and I'm very proud of my tenure on that court.
And Scott, if I may, just perhaps it'll be easier for perhaps some of you to appreciate, even with Title III wiretaps in routine, typical drug conspiracy investigations, from time to time, agents and an assistant U.S. attorney will come to a U.S. federal district judge who will find some defect in the warrant application, which requires a very super probable cause to get a wiretap domestically under the Crime Control Act. And the agents and the assistants will go back to their office for a day or so and tweak it and work on it and bring it back to the judge, and the judge finds it appropriate. So what Judge Walton is describing is not new in any way.
Right.
In fact, interestingly, they looked at statistics in the Title III context and actually saw that there was a similar number of approvals in that context as there is in the FISA context. And one of the other arguments that's been made is, well, it's an ex parte proceeding, it should not be ex parte. Well, every time there's a Title III application for a warrant, that also is an ex parte proceeding.
For that matter, a search warrant.
Yeah. One of the things, too, that Judge Walton didn't mention is every judge on his court is personally selected by the Chief Justice of the United States, and there was recently a couple selected. I want to shift now away from electronic surveillance to something in which I obviously have an interest in, which is the choice of forum where you're going to prosecute alleged terrorists. Whether, as I said in my opening remarks, President Obama made the decision that he wanted to use both the federal district courts for trials, as well as military commissions, and there was a 2-page listing of factors that were put out that you could choose which way each case would go. But there have obviously been successful terrorism cases. We had one right over here in Raleigh, North Carolina, which was very successfully prosecuted.
And just affirmed.
Yeah, by your court. But probably one. So that's a reversal of the trend of the appellate courts reversing the district courts. But your court had to deal with probably one of the most celebrated cases that I mentioned, Zacharias Moussaoui, who originally was thought to be the 20th hijacker. And the case was before Judge Leona Brinkema in the Eastern District of Virginia. And God bless her. I mean, she had more things to deal with in that case than anyone I know. And then your court had to deal with some of the issues. And yes, it was successfully prosecuted, but there were some issues that came up. Do you want to discuss that?
Lots and lots and lots of issues. I tell you, if there were an award for judicial excellence, Judge Brinkema certainly deserved a couple of them. Most of you know the story of Moussaoui. He ultimately received 6 life sentences on each count of a conspiracy indictment relating to the 9/11 attack. He was just the defendant who was every trial judge's nightmare, and Judge Brinkema reached down into her soul as a great American jurist and absolutely handled one of the most difficult criminal prosecutions you can imagine. He fired his lawyers. He insisted on a Muslim lawyer, but the Muslim lawyer refused to represent him, wouldn't meet with him. He objected to the use of special administrative means and just made Judge Brinkema's life miserable on the face of it, but she rose to the occasion really in dramatic fashion and handled and managed that prosecution with aplomb and dignity. She did a couple of very interesting things. One of the things she did when he finally decided to plead guilty, normally when a defendant in federal court pleads guilty, it's of course all public, out in the open. The judge questions the defendant extensively. What she did in this case, because of the particular circumstances, she actually did two guilty pleas. She did a private guilty plea, which is now public, but a private guilty plea with just Moussaoui and his lawyer, who was still acting as standby counsel, not actually representing him. And she made a record that was absolutely bulletproof. She went over with him many times, for example, that his lawyer was encouraging him not to plead guilty. Because remember, this was a capital case. And so she made this record ex parte with the consent of the government, and then it proceeded to the sentencing phase. And he continued to act strangely, contrary to his interests as a capital defendant, but got the mercy of the jury that no doubt applied the law correctly, as I believe juries do. And so he didn't get the death penalty. He ended up with life sentences. The case came up to the Fourth Circuit. It was argued twice, by the way, because some of you may not know, our former Chief Judge, Judge Williams from South Carolina, recently deceased, was diagnosed with early Alzheimer's, early onset Alzheimer's. And virtually as soon as she became aware of this, she stepped down from the court. And Judge Traxler, earlier than he ever anticipated he would, became Chief Judge. And the Moussaoui appeal had been argued, but not yet decided at the time Judge Williams, former Chief Judge Williams, was diagnosed. And so the case was re-argued before a three-judge panel. And as it turned out, Judge Traxler happened to draw the short straw, so to speak, but wrote an excellent opinion really detailing in great minute specifications all of what had happened in the course of the trial in the Fourth Circuit, giving full consideration to all of the many issues that had been raised on appeal by excellent counsel. And I should mention, by the way, again, a quick indulgence, as much as I've celebrated the work of federal judges in this post-9/11 era, I also want to celebrate the incredible work of military and civilian lawyers who have just done a fabulous job. And Mr. Moussaoui got the best legal representation before our court that could possibly have been afforded to him. And so American justice is real and is perceived to be real, I think.
One of the issues that I recall from the opinion out of your circuit, Judge Davis, was that because there was Judge Brinkema had ruled that she had judicial reach to a CIA site because Moussaoui wanted the presence, or at least the testimony, to use in his defense from someone in CIA detention site, which they had not been released. That didn't happen until 2006. And she said she had authority. So that was obviously going to be an issue. But if I recall, what your court said was the evidence was not classified at the time, but would be classified, and therefore you used as a model a Classified Information Procedures Act. Could you explain to us a little bit how that works?
Yes, one of the ongoing disputes between the judge and the defendant was over his access to classified information. And indeed, one of the interlocutory appeals that went up to the Fourth Circuit was Mr. Moussaoui's attempts to subpoena enemy combatants who were being held by the government. And Judge Brinkema put in place very carefully designed Classified Information Procedure Act procedures to protect national security information from disclosure to anyone but the lawyers who from time to time were representing Mr. Moussaoui. But I should mention, by the way, this is, again, not unusual. it does happen in routine criminal cases from time to time in every district that the circumstances surrounding threats to witnesses or for other reasons, standard discovery agreements between United States attorneys' offices and members of the defense bar permit defense lawyers to see certain discovery material, but not the client. And the courts have uniformly held that in the appropriate circumstances, this is perfectly consistent with due process and the rights guaranteed to criminal defendants. They howl and moan about it, of course, and some of them actually attack their own lawyers when they won't give them this discovery. But the law is perfectly clear that in the appropriate circumstances, this is what can happen. So in Moussaoui, every lawyer representing the defendant had to go through a carefully conducted screening process. Several of them successfully did so, but others wouldn't submit to the process or for other reasons simply were not screened and did not get to participate as they perhaps would have preferred.
And as you say, Classified Information Procedures Act is used routinely. Matter of fact, Judge Sentelle, when we have our annual program here at Duke for judges coming in, federal judges, he talks about it. Judge Frank Whitney had to deal with that when he was prosecuting the terrorism case over in Raleigh. So it's kind of
Also, when he was my law clerk, he dealt with
he
it.
did.
My son, years before the Moussaoui case, clerked for Judge Brinkham, as it turned out, and she happened to have a case that involved the classified information, and he had to go through an FBI screen as well.
As I said, I want to be very, very jealous about leaving time for Q&A, so I want to pose one last question. And Judge Sentelle, I'm going to return to you on this one. Again, we're in an area where you're dealing with Eric Snowden, you're dealing with other folks who are leaking classified information, either to papers or to specific journalists. And this whole debate continues on, does a journalist, whether it be Judy Miller or Jim Risen, do they have the authority under law, either statute or common law, to resist revealing their source? And you had the Judy Miller case, and I think it was 2005, where you wrote what I think is a seminal opinion on this whole question of the journalist privilege. Will you tell us about that?
The answer to your question, does the journalist have such a privilege? Judy Miller received classified information from a high government official. She said she did so under a promise of confidentiality. This was a confidential source. She claimed a privilege not to reveal that when she was subpoenaed to the grand jury. I think, Reggie, you eventually had the criminal case, but Tom Hogan had the proceedings.
And we should, now, we're talking about the Valerie Plum disclosure is what we're talking about. And there is a statute that criminalizes the disclosure of a covert CIA agent.
The grand jury said she had to testify. Question is, did she have a privilege to withhold the information that's the identity of her source? The answer is no. Scott, you called my opinion seminal. I don't think so. I think Brandsburg decided the case in the Supreme Court many years before. That was a drug case, not a classified information case, but the question was the same one. A reporter had information, published the information, but refused to reveal source. Now, Judy Miller did not, in fact, publish, but another defendant or another witness in the same case did. In any event, in Brandsburg, the TV reporter did publish the information, but refused to name the source. It went all the way to the Supreme Court. The Supreme Court, in a 5-4 decision, now, I'm going to step aside and say some people will say it was 4-1-4. It was not. Justice Powell wrote a separate opinion, but he also fully concurred in the majority opinion. Justice White, I think, for the court said such a privilege would exist only if you thought it was more important to write a story about a crime than it was to prosecute it. There was no privilege of reporters known at common law. There is not one created by the freedom of the press. Said a while ago we could hold a seminar on some of these subjects. I did a 1-hour address on a paper for Cato Institute recently on the meaning of freedom of the press. The words "the press" in the Constitution do not refer to an occupation of people who are the press. They refer to communication by the press. Each of you has the same freedom to publish that Judy Miller or the New York Times has. It does not create some special category of person who has a different privilege, a different right than the rest of us. There is no constitutional privilege for the reporter to protect a source. Now, the question that came to it in Judy Miller, where they were trying to distinguish Brandenburg, they said, well, that was talking about constitutional privilege. There is a common law privilege that has derived in the courts, a common law privilege to protect the reporter's source. Now, there were actually 3 or 4 opinions in the Judy Miller case, Henry Sealed case. In my separate opinion, I pointed out that the Supreme Court, I think 9 times, used the term common law in Brandenburg. I don't think a common law privilege can exist in the same universe with Brandenburg. Many states have shield laws. Many of the states have passed various degrees of privilege that are accorded by statute to reporters. First difficulty in that is how you define a reporter. One of the reasons why I think such laws are not a good idea is how do you define a reporter? Does somebody who is rich enough to open a newspaper get a different right than somebody who communicates by creating a blog or by, in the old days, Dan, using a mimeograph machine? Why does somebody who has more money get more privilege than somebody who has less money? That's one of the difficulties with the shield law. But there are such statutes. There have been efforts made in Congress to pass such statutes, and if such a statute is passed, we will, of course, follow the law like we do with everything else. But right now, there is no constitutional privilege. There is no common law privilege. If you receive criminal information or classified information, know that you will be subject to subpoenas, be subject to forced disclosure. Now, different departments of justice have, for reasons of policy, made the decision not to pursue the remedies. But they are there anytime that the prosecution wants to take you to the grand jury or take you to court and say, who was your source? The reporter is compelled to answer. And Judy Miller did go to confinement because she refused to comply with it.
77 days, I think it was.
77 days, I think it was.
I mean, there's an argument being made that the Brandenburg authority only applies in the criminal context and not the civil context. And I had a case, and I was hoping it would go up to the circuit. It was the Stephen Hatfield case. He was the individual who was charged with the anthrax mailings, and leaks were being leaked to the press by obviously members of the government in reference to Hatfield, and had a devastating impact on his life. He had a job he had just taken at LSU, and he lost that job as a result of these leaks because it was believed that he was the person responsible for the mailings of the anthrax. And ultimately that proved not to be the case. Well, there were 5 reporters who were identified as individuals whose information had been leaked to, and I held all 5 of them in contempt. One of them I ordered to pay a large amount of money on a daily basis until she complied, and I was, again, hoping that that case would go up, but it did not because the others folded. They did reveal who their sources were. It was the number 2 person in the United States Attorney's Office and a top official at the FBI who had been leaking the information. Once that came out, it was clear that there had been a Privacy Act violation, and the government settled with Hatfield. I believe it was for about $5.4 million. And as a result of that, the case resolved itself, so the case did not ultimately go up on appeal. But if there had been a shield law in place that would have shielded disclosure of that information, Hatfield would have never received any justice for the wrong that was done to him as a result of those illegal leaks.
You know, I think one of the maddening things is that on so many of these decisions that we've talked about, and I also am thinking about the extraordinary rendition cases, particularly out of the Fourth Circuit, Ninth Circuit, Second Circuit, where the Supreme Court has denied cert. They have said, we're just going to leave it as the law, even though you've got a split in circuits, perhaps. And so that kind of puts the burden back on you, whether it be the appellate courts or the trial courts, as far as how do you apply it. I want to go back to something Judge Davis said, though, in your moving comment about the judiciary and how they have functioned, particularly since 9/11. Chief Justice Rehnquist wrote a book, I think it was 1999, called All Laws But One, and he wrote about some of the famous national security cases that we teach our students, the Kawamatsu case. And he said, you know, there tends to be, in a time of national crisis, a deference of the judiciary to the executive. And even Judge John Bates, I think, in the LAWshaping case, suggested that this was really perhaps more a matter for the executive branch than the judiciary. So let me ask all three of you as we close, and then I turn to the questions. In this area of national security, particularly as long as we continue to have a threat of terrorism, what is the competence of the judiciary, and when do you feel in any given case when it really is an executive decision that should be made? Judge Sentelle, I'll start with you.
It's hard to give a short answer to, but the fact is that we are not experts in national security. We had a case involving an attempt to obtain information. It's a FISA case, I guess. Excuse me, a FOIA case where they were trying to seek information about the people who had been picked up in the wake of 9/11. We noted in there that we don't even have the agents to investigate these things, and the people litigating in front of us on one side don't have the information, the other side can't give the information. These are matters that have to be handled with both expertise and privacy, because you don't let the enemy know what you're doing. We're not equipped to do either one with the same efficiency that the executive does. They're the ones who carry out the law. All the laws but one, Chief Justice Rehnquist suggested, I think rightly, that he was quoting Lincoln, that Lincoln said it didn't do to preserve the Constitution at the expense of all the other laws. That we gave up all the laws but one that way, and we gave up all of our freedom except the one that way. We lost the war because we gave up everything except the one. I'm paraphrasing both Rehnquist and Lincoln on that, but the idea was there, and it makes sense. We cannot, in the courts, run the war. The executive has to do it. Now, we in this country have done a very good job, I think, of trying to preserve the rights of the people insofar as possible, consistent with preserving the nation in which the people live. But we're not equipped by either expertise or resource to do the job.
Yeah, Judge Walton, both in your hat as a district court judge and also on the FISA court, I mean, how do you view this? How much do you defer to what the executive branch brings to you?
I mean, I agree with what was just said. We have limited capacity to address many of these matters that come before us, and we do the best that we can. And I agree with Judge Davis that we tend to do a pretty good job at it, but we can't take over the war effort. That's the role of the executive branch. And I do want to say also, in reference to the intelligence community, I have the greatest respect for the people who work in that arena, and my respect for them has only been enhanced as a result of my tenure on the FISA court. You've heard about a number of transgressions that have occurred in the context of the electronic surveillance that our intelligence community has been involved in. And how do we know about those transgressions? We know about them because the intelligence community has come to us and told us about those transgressions. We don't have, as a court, the capacity to investigate whether our orders are being complied with. And the only way we know whether they are or not being complied with is the information we get back from the intelligence community. And I think they've been vigilant in bringing that information to us, despite how embarrassing it may be. And we talked earlier about the complexity of technology. And I think to a large degree, some of the transgressions have occurred as a result of that complexity, because it's a cat and mouse game. You've got the bad guys who are improving their capacity to do what they're seeking to try and do through technology, and you've got our intelligence community trying to stay abreast of what they're doing. And I think a lot of times there are technologies developed in order to detect information or detect potential threats, and the intelligence community believes that they fully understand how these processes are going to work, but when they're put into place, they find out that there are things that don't work, and sometimes they're collecting things more so than what they thought they would when they brought it to the court. But I have not, in my 7 years, seen an instance when I believed that the intelligence community willfully brought to me false information for the purpose of trying to conduct surveillance. I think they've been oversight, they've been mistakes, But when they're made, I have the confidence, based upon my experience, that the intelligence community will bring that information to us, despite how embarrassing it may be, so that they can try and redress those problems.
Judge Davis, last word from the bench.
I think my colleagues have expressed very profound thoughts in a very moving way. I think in this post-9/11 world, among the various characters you're looking for from your judges, independence, collegiality, thoughtfulness, you're looking for humility, which is, I think, what they're describing in a word. The balance of power is very critical to our democratic processes, and courts certainly have an important role to play. We are not an anti-majoritarian institution, but we are a counter-majoritarian institution. But when it comes to issues of war and national security, we need to bring a healthy dose of humility and respect for the greater competence of our co-branches of government to keep us all safe. I think it was Justice Jackson who said, Constitution is not a suicide pact.
And Justice Jackson, I think, also was the one in the Korematsu case who said, this is not something that my court should deal with. It should be left to the political branches.
That's right.
All right, now it's time for you to voice your thoughts. Yes. Let's make sure we get the microphone, and if you could wait until the microphone gets to you, because we're trying to make sure we have an accurate record.
Thank you very much for all of your comments. I'd like to ask a question relating to this last point. I'm very familiar with all these cases. I've worked on many of the cases that you've discussed here. And the idea that the executive branch is better suited to deal with a war effort, I think conceptually makes a great deal of sense. But the cases that you've worked on represent examples of the executive branch violating the law, whether it's domestic law, the U.S. Constitution, or international law. And in many cases, the only way that we know that is because judges such as yourselves examined those cases. So I wonder if you could speak a little bit about how to deal with the risk that the executive branch, which is co-equally charged with following the law, may not be, and whether that affects the role of the judiciary. And we have referred to Congress, but of course they play a similar role. And I wonder if perhaps what we're dealing with now is that in the last decade plus, there have been failures on the part of other branches to perform their obligations, forcing the judiciary to step in areas where it might not have otherwise if those branches of government had indeed been completely following their own obligations.
Well, I mean, obviously, under the FISA statute, there's a role that the court has been given, and I think we have vigilantly sought to carry out that role. I think you've seen with some of the recent declassified opinions that the FISA court has taken the executive branch to task when we've found that there was noncompliance with orders that we've issued. That is not to say, however, that I feel that the judiciary is more competent to carry out the war effort as compared to the executive branch. I think it is an executive branch role, but I think within our constitutional structure, there is a limited role for the court to play in matters related to, for example, electronic surveillance and authorization by the court for that to be conducted.
Excuse me, go ahead, Judge Sentelle.
There comes a point when if the allegations are sufficiently credible and sufficiently serious that the court may at least have to require some sort of in-camera showing from the government, not disclosing to the public or to the record what the government's been up to, but at least enough to let the court know whether the rights have been valid. And now the difficulty we get at that point is sometimes you get that Glomar response that's going to say, well, we can neither confirm nor deny that we even have that information. That comes a state secret question, and it becomes, I'm afraid, Andrea, an insoluble problem. That if the government's allegations of the danger to national security are credible enough and they're never specific, because they say, well, if we make them specific, then we're blowing the need we have to keep it secret. We're afraid perhaps not to allow that deference if it sounds like there is enough risk to national security. The government, however, we have to try to prevent the government from running behind national security to justify every time it wants to or finds itself in the habit of or in the process of violating personal rights. We have to be careful not to let them run behind that. So on the one hand, we have to try to help. We have to recognize the executive's privilege in national security. On the other hand, we have to try to prevent the abuse of that privilege. I know I'm not giving you an answer, but I'm at least posing to you that is the dilemma that we face. The closest we can come at times is an in-camera order, and sometimes they won't comply with that.
Yeah,
Continued diligence by organizations such as your own is critical.
Yeah.
Keeping the balance true.
I mean, one of the concerns I've had, I think a third-party advocate before the FISA court in certain limited capacity could be helpful. But if there's carte blanche right to appear before the FISA court and have access to the information that the court is considering, I think one of the potential problems is that they're going to be information that is so significantly classified and so sensitive that the government may make a decision, we're not prepared to reveal that information for the purpose of trying to get an application from the court to authorize us to conduct certain surveillance. We're not willing to give it to that third-party advocate. And if we have to, we'll take our risk in getting an order without it, which means they may not get it, which means we may be at greater risk if they don't have the ability to conduct that surveillance. So it's a complex issue. It really is. I handled the Scooter Libby trial. And in that trial, even though it was Scooter Libby in the position he held previously, there were circumstances where the government said this information is so significant to national security that we will take the risk of losing the case by not revealing it. And that conceivably would happen in the context if you have this third-party advocate who would have a right in every case to intervene.
And that happened in the SEPA context in your circuit. Fernandez, I think is the name of the case, where the Attorney General said, look, this is too sensitive an information. We cannot reveal it. And the judge said, okay, I'm dismissing the case. And the Fourth Circuit said,
That was the end of it.
And it must
dismiss the
The
case.
Attorney General was the only one authorized under SEPA to do that. And by the way, for the record, the questioner was Andrea Presal from Human Rights Watch.
And one more short thought. On a lot of these, I know ex post facto relief is not effective, but a lot of times if the question came back to us after the lapse of time so that the national security interests become less or less convincing, then it might be that the same relief sought earlier could be granted if it came back at a later time, or a later court away from the heat, Korematsu, away from the heat of the times, may later, even the court may say, look, we were wrong that first time.
Before I go to Bill, there was a question in the back. Yes, sir. And if you could identify yourself before you ask your question, please.
Yes, sir. My name is Brian Hayes. I'm a prosecutor in Newport News, Virginia, also an officer in the Navy Reserve. My question is most specifically directed to Judge Walton, and it's whether relevance means something different in a FISA context than it would in a criminal investigative context. Pursuant to a relevance standard, if a prosecutor were to subpoena telephone records in a criminal investigation, I think one might give them the target's records, perhaps the records of those persons called by the target or calling the target, but really no more than 1 or 2 degrees removed. I don't think it occurred to anyone before the Snowden leaks that the government might subpoena the records of millions of subscribers under a relevance standard pursuant to an investigation. And it seems like, in a sense, that's what the NSA program consisted of in a national security investigation, collecting millions or hundreds of millions of records. So is a relevant standard different in a national security context than the ordinary meaning in a Title 18 context?
Well, the opinion that was issued, not the most recent approval of the 215 program, but the one before that, said that based upon the wording of the statute, that the definition did have a broader meaning than in the criminal context. I think that is one of the most challenging issues that the court has had to grapple with, is the issue of relevancy. But if you look at it from the context of how the program works, the program probably does not have any effectiveness unless you have this broad bank of information that's available to run a check to see if you get a hit once you've identified a phone number that's associated with a terrorist. If you don't have that broad bank of information, then you're probably not going to potentially make a hit on someone who may be within the United States, who may be planning to engage in terrorist activity with that phone number that the government has identified. So yes, I think it does, at least under certain circumstances, have a broader meaning than it does in the normal Title III or criminal context.
And Professor Bill Banks from Syracuse.
You know, Scott mentioned it in his opening remarks that the Congress has forbidden the transfer of any detainee from Gitmo to the United States for trial or any other purpose. Looking ahead, should that condition change? Should the president, either through some political deal or a change of heart in Congress, persuade Congress that he should be allowed to close Guantanamo and that at least some of those detainees should be moved to the United States for trial? What do you see as the challenges in adjudicating the detainees who've spent all this time at Guantanamo Bay?
I'm not going to answer the should question. That's for others. But I have no doubt whatsoever, as a United States District Judge, United States Circuit Judge, now for nearly 20 years, that the Article III judges in this country could, with absolute dignity, full control, try any detained person under criminal charges brought by the government. I have no doubt about that. That's not to suggest that the alternative systems now in place do anything less than that, but I have no doubt about Article III judges.
As a matter of fact, I didn't mention it, but the only Guantanamo Bay detainee that was brought into the United States for trial before the congressional ban went on was El Giuliani, who was prosecuted up in the Second Circuit. And I think there were like 272 charges against him with regard to the 1998 embassy bombings in Kenya and Tanzania. He was convicted of only one, but yet he got a life sentence. So, you know, that's kind of a mixed case, but nonetheless, I think, I don't know of anyone, even those who favor the use of military commissions, that say that a detainee at Guantanamo Bay could not get a good, fair trial in the United States Federal District Court.
Well, I'm satisfied that they could get a good, fair trial. I agree with Andre to that extent. I do not, however, think that that establishes that it's a good idea to do it. The Moussaoui thing is one example. We don't need the burden of that on the courts unless there's some reason why they have to be tried here, and I don't think they have to. So I would not add that to the workload. I'm not at all worried about what's going to happen in the courtroom, but it's what the system's going to do. But I think the burden of what the Guantanamo litigants would do, and in some cases what the public would do in reaction, is something that I'd rather we not have to deal with. Well, I had this discussion with Royce Lamberth at the time that the president was talking about trying the Guantanamo cases in our district in part. Royce had the same reaction you did. I had the same reaction I do. That is to say, Royce was perfectly ready for them to come ahead and do it. And with his usual lack of judgment on this particular point, he said that in front of a media person. In the process of cursing him for talking to the media, I also said, I think we got more problems here than we need to take on. Yes, we can do it. But is it a good idea for us to do it that way? I don't think so.
Yeah, and I should mention, I don't think many of you are that familiar with the appellate process for any cases at Guantanamo Bay. Once they are approved after trial by the convening authority, then it comes to my court And we have the authority to rule on issues of law and fact. And then my superior court is Judge Sentelle's Court of Appeals to the District of Columbia Circuit, and then to the United States Supreme Court. So there's a very robust appellate system, all of which is free of charge. Jeff, last question, if you can be very, very brief.
No last question. That was the last question.
That was the last question. I stand corrected by the Commander-in-Chief. All right, well, will you join me in thanking our judges?
I think there's only one word to describe what this panel was. Absolutely spectacular. It's going to be one of the things, anyone else in the audience, you're ahead of the game, because I can tell you when I teach national security law, at least for the next very few years, you're going to have to watch this tape. So it absolutely spectacular, and, you know, it does really renew my faith that I hope I already had in our judiciary, to see the quality, the candor, and the dedication of these judges, and I mean all four of them. This is legendary. I know we get to a certain age, we don't like people referring to us as anything about legendary, but really that was legendary. Okay, folks, please step out. Pick up your box lunches, come back. We are going to be starting exactly at 11:45 with another tremendous.
Well done as always.
Thank you, sir.